Representative Greenberg, to recognize. Just remind you, we do have other people that want to speak. So,
Ms. Mims, I have a question for you about Harris versus McRae. That was an old Supreme Court case which upheld the Hyde Amendment and said that the Hyde Amendment, limited federal funding of abortion. And the court held in that case that the Hyde Amendment didn't rest on a constitutionally suspect classification. Is it your opinion that there's a significant possibility that if we have strict scrutiny of women as a class, and that ruling, Harris versus McRae, might change and so weaken the grounds for the Hyde Amendment and make it more likely we're going to have federal funding for abortion?
Well, I'm not a lawyer. I'm not familiar with that case, but I do know that because abortion is, only women can have abortions, so any law that is gender specific like that, I believe, would be at risk.
seeing no more questions, thank you. At this time, we'd like to recognize Gloria Gordon to speak for the resolution. You're recognized, Ms. Gordon.
My name is Gloria Gordon, and many of you know that I'm an unpaid advocate for the elderly and people with disabilities. I came by my advocacy from my mother. My mother was an advocate for women's rights and for civil rights. Wherever Ms. Shafley was speaking against the ERA, my mother was there speaking for the ERA. She marched with Martin Luther King. She marched in Washington and Chicago. She was always on a bus headed somewhere to march for the ERA. And I just want to put this issue in a personal context. You've heard all the legal issues for and against. My father died in the early 70s, and my mother went to settle his estate, and they were living in the state of North Carolina, and all their property was in...
Thank you, Mr. Chairman and members of the committee. My name is Martha Adcock, and I am the staff attorney for the Family Council. I also have one other hat that I have worn in prior years that I'm going to emphasize in my testimony here, and that is with the Arkansas Marriage Amendment. I had the privilege of being the attorney that defended the Arkansas Marriage Amendment for the Arkansas Supreme Court, because it was part of that Arkansas Marriage Amendment Committee. And while I think maybe back in 1972, when this whole issue was debated originally, I don't think same-sex marriage was on the table. And I'm not sure that was a big part of the discussion then. And I wasn't part of that discussion then, wasn't old enough to be part of the discussion then, but I'm not sure that it was. But it is a big part of the discussion here today. And so that's part of what I'm going to emphasize. First of all, I really appreciated what one of the other folks has said, and that is I still haven't seen what I consider to be a need for the ERA, other than to make us feel good to say that we've put it in a constitution and that it's there. Because there are not, that I have seen, examples that folks have testified to today to say, here is the area where women are being discriminated against. And I've talked to many of you here on this committee, and I've said, if there is an area, let's find it, let's take the steps, and let's correct it. Now, we've talked some, and there has been some general testimony about economics. Well, if there really is still disparity in regards to economics, then let's tackle that issue and let's fix it. But don't take something for which you don't know what all the consequences are going to be to change the highest law of the land, the U.S. Constitution. Representative Sumter asked what I consider to be some very good questions on the impact then of what this particular resolution would do to the Arkansas Marriage Amendment. And I agree with him. This particular piece of legislation, the HJR, if it were to pass here, you're not going to get the Arkansas Supreme Court overturning the Arkansas Marriage Amendment. But if you get those 38 states, it becomes part of the U.S. Constitution. And said in simple ways, guess what trumps? The U.S. Constitution trumps. And lawyers know this, that right now we have a lot of cases where folks have used state ERAs to overturn marriage amendments? Not a lot. But you do have the precedent, and you do have it in concurring opinions and in dissenting opinions, which is exactly how these momentums build, and then what judges, when they're wanting to overturn precedent, that's what they use. Where was this argued before? And if you go back and look, it's been argued. It was argued in concurring opinions in the Massachusetts decision of Goodrich. It was argued in Maryland. Now, it was over, again, those in Maryland, it didn't stand, but it was used. And I still haven't heard anybody specifically talking about a case that I find to be extremely troubling, and that in Baltimore, Maryland, Dean versus Conway. And the case is on appeal right now, but you have a judge who specifically said, here are multiple reasons why maybe you could use that the plaintiffs argued to overturn the state marriage laws. They argued equal protection, they argued ERA, they argued several, and the court said, I'm coming down boldly and 100% on ERA. And they threw out the state marriage laws. Now again, that is on appeal, but that's a very dangerous precedent. And it's been argued multiple times here, well, would the courts really intervene? Because the only time they've really intervened in marriage is in regards to loving. And if any of y'all have the decision, I would draw your attention to page 7. What case did the judge use? And what case are they talking about? Loving versus Virginia. So for you to think that because that the U.S. Supreme Court or the federal courts would not step in, they only did it in that one circumstance, that does frighten me as to think where we're headed. And Representative Smith, I think, was dead on when she was talking about when she was talking about due process, and there were questions and saying, well, what does due process mean? And she is so right, because I quoted it, and she said that now it is very clear how it is applied. But we've had lots of years in which we've had court interpretations and decisions. Ladies and gentlemen, we do not know clearly how the ERA is going to be applied. And that is what concerns me, that you're then going to have federal law trumping all of our state marriage amendments. Now, in Hawaii, that question was specifically asked about Hawaii. Do they have a ban on same-sex marriage today? Absolutely they do. Hawaii was one of the very first states to pass a marriage amendment. Why? Because a trial court using the state ERA said the state laws against marriage, they invalidated them. Now, was ERA the only basis that was used? It was not the only basis, but it was one of the bases that was used for overturning marriage laws that said one man, one woman. Hawaii went, this isn't what we want. So even before same-sex marriage became a national debate, Hawaii went off and passed an amendment to their constitution that says marriage is between one man and one woman. And they felt compelled to do so because of what the courts had done. So today, is there same-sex marriage in Hawaii? No. But the two can coexist because they're both in the Constitution. We do not have a federal Constitution amendment for same-sex marriage. So that's part of what concerns me. And my only other comment, because I've read them, is on all these things about the constitutions. I think it's very dangerous to take them. I've read them. And when I heard that, I have not read Japan's because I didn't realize that one was going to be discussed. But I looked at both the Iraqi and the Afghanistan constitutions. They're very different from ours. And just because there may be a principle in there, that concerns me as to how then that is going to be interpreted. And I still think you have, as clause number 3 in both constitutions, that you can do nothing that violates the Islamic law. And I'm not sure you would get some of the same things that we have concerns with here today. So I appreciate your attention. The committee has been wonderful to stay with it for this long. So thank you.
Thank you. And before we move down the list, we've got 7 more people that want to speak, and we're going to try to limit that to 20 minutes. And I would ask that you limit your comments to statements that have not already been.
Very much, Mr. Chairman. This discussion today has been very educational for me. I've been attending such things in 3 states. In Florida, when I was a young woman, we just got ERA started, and then my husband moved me to Colorado. We took up the